Hi guys, my name is Raffaella De Santis. I'm a lawyer at Harbottle and Lewis, and I specialise in the protection of IP and rights, in particular actually music and digital rights, but the broad spectrum of IP and copyright. And I was very kindly asked by Joseph and Elodie to come and talk to you today about how you can protect your ideas in the context of the theatre industry, but in the creative industries in general, what those rights look like, how they arise, and how you can exploit and protect them. So I hope that everybody can see my screen and see the first slide of the presentation. Shout in the chat if you can't, and Joseph will let me know, and we will get going. So the starting point, and the starting point for any law student actually, is how on earth do you actually protect an idea? It sort of formulates itself in your mind and you think about it, but at what stage does the law actually protect an idea? So we have a series of statutes and also common law rights which will protect ideas, but they will protect those ideas which are recorded. So we have copyright, we have trademarks, which are both registered and unregistered trademarks, patents, which we're not going to discuss today, design rights, which we may touch on slightly in the context of designing sets and get-ups, but we won't spend much time on it at all. Know-how and confidential information, which we may talk about a little bit, and data, which I don't anticipate we'll touch upon in this session, but it's good for you to know that you've got rights of data protection and how to protect your ordinary data and your sensitive data. So what are the principles of copyright? Everybody talks about copyright, but it's actually not necessarily well understood how you can how copyright arises in a work. And what are the bodies of law which actually dictate how we protect a copyrighted work? So we've got international treaties and conventions, the Berne Convention. We've got national copyright legislation in each jurisdiction of our previous membership of the EU and throughout the world. And we have European Union directives, some of which we will continue to follow and grandfather into our own domestic law as we have now left the European Union, and some of which we may seek to create independently and anew. So what's the legal status in the UK? And I use the UK to mean a geographical territory, but we actually have separate laws of England and Wales, Scotland, Northern Ireland. In the UK, governing all of those territories, we've got the Copyright Designs and Patents Act, or the CDPA, 1988. Copyright law originated from a concept of common law back in the 1700s, and it became statutory in 1911. And the current act that we lawyers look to is from 1988. And it gives creators, I can't see half that slide there. It gives them the rights to control the ways in which their creations can be used and protected. So what's protected? And we use the acronym LDMA, so literary, dramatic, musical and artistic works. It also protects sound recordings, films and broadcasting. What it doesn't protect is the idea in and of itself. So you've got to record the idea in some fashion. What do we mean by these types of work? So a literary work could be a script, manuscript, a letter, song lyrics, leaflets, newspaper articles. Dramatic works generally mean plays and dance. Musical works, sound recordings and the score, the composition. Typographical arrangements, so not just the article in a newspaper, but the way in which the typographical arrangement of the newspaper page is arranged. From an artistic perspective, it protects photography, painting, sculptures, technical drawings and diagrams, sound recordings separately to musical compositions, and film footage, broadcasting, television programs, etc. So how do you get copyright? How do the rights occur? In this jurisdiction, copyright is automatic and it comes into being on creation of the work. So the minute that you create the script, you write it down, you write the treatment, you design the costume or the staging, or you write the song, the minute that it is recorded in some permanent form, it becomes a copyrighted work, a qualifying work. And it protects the expression of the idea, not simply the idea itself. It has to be an original idea. It can't be a copy of somebody else's idea. But under English law, the concept of originality is a pretty low bar to satisfy. You have to have expended some labour and effort, put a bit of sweat into it. It has to be your own original work, not otherwise created by somebody else. And that's generally about it. The kind of things that perhaps wouldn't attract copyright might be, say, the phone book, for example. Just an ordinary arrangement of names and numbers would not be original enough to attract copyright protection. Who owns the work? This is one of the most important facets of how you protect your rights. And it will ordinarily be you, the author, or your co-author. So the people who first created the work will be the first owners, and they will own the copyright in the work, except where the work has been commissioned by another person and paid for. And so, although you will be the first owner of the work, you will have agreed, because you have been paid to create it, that the purchaser of that commission will ultimately own it. And another exception is if you're an employee. If you create something during the course of your employment, it will belong to the employer. And in the US, that's also called a work for hire. We don't have this concept in UK law, but if you're dealing with American companies, if you are being commissioned by American companies, then that is a concept that you might come across. How long are your rights protected for? So the right arises automatically when the work is created. And in this jurisdiction, you don't have to register a copyrighted work, as in some other places, America being one of the main ones. There are some advantages to registering your work. It means that you've set down in stone the date on which it's come into being, so it's quite easy to see if somebody else has purloined it and used it for their own purposes. But in this territory, we don't need to register. For literary, dramatic, musical and artistic works, they will be within copyright for the duration of the author's life plus 70 years, and that includes plays. Sound recordings is an interesting one, because only very recently has the law changed here, and it has changed due to a European directive which extended an anomaly, which was that sound recordings were previously only protected for 50 years. And what this meant was you had a lot of record labels reissuing and remastering music in order to create a new copyright in the new master of the song. And what the extension in the law has done has harmonised the rights in sound recordings with that of the other types of protected rights. I'm just checking if there's anything else that I want to add to that. So for those of you who are in music, it means that where sound recordings and performances would have come out of copyright protection after 50 years, they're now protected for another 20. And that means that there's additional protection for those works that were created between 1963 and 1968. So it means that the impact of the new policy is going to grow over time. And by 2033, there's going to be a full 20-year period for which the recordings would have been protected. They think that it might raise an approximately more than 2 million extra royalties to those artists who would have been affected by that policy. So it's quite an important change in the law if you're making sound recordings, whether that be of music or performances, actually. How can you infringe copyright? So the first way is just by copying it in any material form, whether you copy it in whole or in part. It can be direct or indirect. You could have intended to rip off a work, or you could have included it incidentally or accidentally in a work that you are creating. It could be subconscious. Maybe you overheard a play being performed or a song being sung and you've forgotten where it was and suddenly it comes out. The phrase inspired by has come into common parlance when people are talking about use of other people's work, both in dance, music, dramatic, you name it. By taking a 2D representation of an idea, say a painting or a picture, and creating it into 3D, so for a film or a theatre set. It includes transient or incidental copies and photography. So one of the interesting differences in the protection of photographs versus other types of copyright work is that the author of the photograph will not be the photograph subject. So if you took a picture of me right now, which I hope you don't, because I'm on lockdown chic, it wouldn't be me who owns the copyright in the photograph, it would be you as the photographer. What would be your defences to infringement if, for example, you found yourself in a tight spot where you had been inspired by somebody else's work, or you had copied, whether consciously or unconsciously, somebody else's work? So under English law, we have a concept of fair dealing, where there are permitted uses of other people's work for certain purposes. And those are for criticism or review, especially in the context of news or parody, quotation, and reporting current events. Other defences will be that the copyright of the work has expired, or the person alleging that they are the owner of the work that has been infringed doesn't own it, or there are some imperfections in their ownership. Or maybe you haven't copied a substantial part of the work at all. Maybe you've copied something which is so small that it really is has done no damage to the copyright owner at all, and it really isn't worth bringing the action. Having said that, there was a recent case in Germany, actually, where a long-running piece of litigation between a German music producer and the band Kraftwerk had been ongoing, where the German court found that the music producer who had used a 2-second snippet of a sound recording of Kraftwerk's Trans-European Express had actually infringed their copyright. And lawyers like me were quite fascinated by the judgment, because to say that the use of a 2-second snippet of a sound recording could be copyright infringement for which they were liable to pay damages is very interesting and seemingly quite harsh. So moving on, what can you do? You can use other people's work for private and study purposes. You can use it for performance, for lending or educational purposes. Criticism, news reporting, incidental inclusion. Copies and lending by librarians, good for the librarians. Caricature, parody or pastiche. Anyone who remembers the original Spitting Image or is a fan of the new Spitting Image will remember that we have a very long history of and culture of parody in this country. Less relevant, acts for the purposes of royal commissions or statutory inquiries, judicial proceedings, recording of broadcasts for time shifting, and producing a backup copy for your own personal use, but not commercial use. Let's talk a little bit now about moral rights. So you sometimes hear this come up in circumstances where usually a writer is assigning their rights or licensing their rights in return for a fee or a royalty, and they are licensing or assigning the copyright. But what happens to the moral rights, and what are they? They are more minor rights, which in some cases cannot be assigned in some jurisdictions, but they are the right to be identified as the author or director of a work, the right to object to derogatory treatment of a work. So this is where someone has taken your work and amended it in such a way that it wouldn't count as parody or pastiche, where it had essentially been vandalized. The right not to suffer false attribution of a work, so somebody else passing off their work as yours or vice versa, and the right to privacy in respect of certain films and photographs.
I come in here, we've got a couple of
Sure.
questions.
Yeah, go ahead.
It might also, if you can see it, be worth opening your chat because they're lengthier ones. So.
Oh, sure. Right. Let me see where I can. Right. Yes.
In the meantime, so we've got Lance says, who owns the copyright if you co-write the work? Also,
Sure.
if you develop the original story idea significantly, such as what happens in films, i.e. significant story changes made by the producer or director to make it viable, who owns the copyright?
Great question. So the technical legal question, the technical legal answer and the real world answer to this question are different. You and your co-writer write something together, you write your treatment and you write your first script. In the world of film, that will at least get you a story by credit, if not a screenwriter's credit. To the extent that that script then continues through the development process and perhaps other writers are brought into the writing table or the producer or director themselves make changes, although you would be the original authors of that original script, and hence why you get the story by credit, because that credit essentially reflects who had the original idea, you all become co-authors of the finished product, which is the finished script. So the question is, how do you want to divvy up ownership of something where it's quite difficult to place a value or a quantity on which bits were changed, who has changed them, what's significant about the story? Is it a main character plot line or story arc that has been changed? Is it something which is more incidental to the plot? Really, there are so many ways to skin that cat, and it comes down to commercial negotiation in the end, which is how much do you feel you've contributed to what is the end result of the script? and how much do the other contributors feel that they have contributed. And it's why you might see certain credits where you think, oh, why have they got 30 million executive producers on this piece of work? And that is a system in the film world of crediting co-contributors without carving up the copyrights in the script or whatever else they've contributed, because the film has got three parts. It's got the story, the script, the filming, and then the editing. And so the finished product is an amalgamation of all of those layers of creations and those layers of rights. So in order to try and give you a clear answer of who owns it, you will all own the finished product. The question of how much of it you own and to the extent which you own it will be dictated by the commercial negotiations between you as to what share of the proceeds you should get from that particular work. Does that answer the question?
Very much so, I think, well, in my mind anyway. Perfect. So we're going to just jump on to the next question then from Gemma at Dance Network Association.
Sure.
I deal with many commissioned works to deliver much of our work.
Yeah.
If we hire a freelance photographer or videographer and pay them for their services, do we therefore own the copyright of those recordings rather than the photographer or documenter? And then there is a second part that says, also, if we use pictures in our resources, i.e. photos, that are not ours, and we add hyperlink reference work, is that okay?
Okay. Hi, Gemma. I'll take those two questions separately. The first answer is, do we own the copyright in the work that we've commissioned rather than the photographer? My answer is you absolutely should own it, because it's your business, you're paying the money, you're commissioning the work. And so what you want in that circumstance is you want to have an agreement with your photographer or documenter, which is called a buyout of rights, where in return for a fee, they will assign the rights in the proceeds of their work to you, the photograph or the video. To the extent that you don't own those, what you would like is probably an exclusive license, albeit the photographer will usually want at least the use to use the photograph in their portfolio so that they can, get other work and say that they've been associated with working with you. And the least control that you would have would be a non-exclusive license, where that particular freelancer said to you, I've taken this photo for you, but I reserve the right to sell it and license it to whomever I like. And there can be validity in that. It depends on what the commission is for, and it depends on what level of control you want over the image, whether it's something intrinsic to your business or whether it's something that's incidental. But from your perspective, you are always going to want to try to own as much as you can in terms of rights, and that will usually involve a higher fee to buy out the rights from the creator than a simple exclusive or non-exclusive license. And then to go on to your second question, if you use pictures in your resources that are not yours and you add hyperlink references, you mean crediting the original author, is that okay? To give you the lawyer's answer, it depends. And it depends on two things. It depends on whether you're using that image in a commercial sense. So you're using it to sell something, to sell your services, to associate with you, or are you using it as part of the permitted acts? Are you using it for news reporting, critique, parody? If it's not one of those things and it's for commercial use, then no, you don't have the rights, and you're going to need to go and get them and possibly pay a license to use that photograph. There are lots of stock libraries where you can either get pictures for free or for a very small low license fee, which you can use. If you want something which is quite iconic, or it's, say, from the Getty Image Library, then you'll need to pay a fee to use it.
Fantastic. Can I just ask a question that hasn't been asked, but I've just thought of it because it might be relevant to a few of the mentees?
Sure.
If you're on the other side of Gemma's question, which is if you're the photographer,
yeah,
a buyout,
Yeah.
what rights do you have to be able to use effectively your work in your portfolio to sell your work?
Sure. So I've got a lot of photographer friends. A lot of my photographer friends are very, very passionate about never selling or assigning their rights. They only grant licenses. If you're a photographer, your main concern is, is what you were commissioned to do something that you need to keep for yourself? And will you have further commercial use for it later? Or is it purely a commission for the commissioner? Are you going to be too bothered about it later on down the line, except for use in your portfolio? If the answer is you think you've taken something which is so iconic, you want exclusivity over it, then you wouldn't agree to a buyout. You would agree to a license. If you've taken something which is only going to be used by your client because it's been commissioned, then as long as you set a reasonable market value for the fee and you retain the rights to use the image in your portfolio to show off your own professional expertise, then you should feel comfortable having sold the rights to the image, because that's why it was created. It was created for your client.
Fantastic. Fantastic. I've got a couple more then, and then we'll move on. So any that we've got in the chat at the moment, we'll stick with those if that's all right.
Yeah.
Adam says, and Adam is a writer-composer. He
Hi,
said,
Adam.
how does it work with new musical arrangements or orchestrations of existing pieces of music?
So this one is very interesting, and Adam, I might need to get back to you in more detail, but the basic premise is it depends on what you're arranging. So if you are arranging a composition rather than a sound recording, which is itself out of copyright, then you will be the creator of a new right in that arrangement. If you are arranging a work which is within copyright, then the original composer will have the right in their own original composition, and you may need to go and get a license from the music publisher to enable for you to commercialize that new arrangement or to record that new arrangement. So there's nothing stopping you in the ordinary course of things of going away, taking a score and going and doing the musical task of rearranging it yourself. But when it comes to performing that new arrangement, recording that new arrangement, commercializing that new arrangement, if it's in copyright, you are going to need a license from the original composer to do those things.
Fantastic. Next one then is from Paula Baker. Paula Baker runs a community, it's a theatre company, isn't it, Paula? And they do primarily work in non-theatre spaces. This one I feel might be a 5-minute catch-up at a later date as well, but it might be very helpful for everyone here. I created a performance piece based on sporting events, which we collaborated with a local community centre.
Yeah.
I was hired for 7 years to deliver my idea. The company works collaboratively with their partners in order to deliver our product.
Yeah.
I was then effectively sacked, even though they had 6 more years funding to deliver the theatre company project. Because there was no contract, they continued to deliver the theatre company project under the same name. I have taken them to small claims and it has gone to High Court.
Yeah.
I'm still waiting for the case.
Obviously more than 25 grand.
Yeah. Where are we?
I'm still waiting for the case to be heard.
I'm still waiting for the case to be heard, but I'm concerned that it is now beyond my experience to deal with, even though it is still in the small claims section. I can't afford a lawyer, and the group that I'm going up against have £1 million in the bank. I'm also concerned as to whether I have done the right thing. My work is not written down, but I have a lot of evidence of how the ideas developed, diary notes, etc., minutes of meetings.
Sure. It's Paula, right?
Yeah.
Paula, I'm really sorry to hear what you've been through. This is really distressing. It's one of those situations which is quite complicated for a number of reasons. You say that there was no written agreement. the company that you've worked for have essentially continued to use your idea, your branding. This is one where I would suggest you and I have a chat offline. I'd be more than happy to have a chat with you, tell you what I think. I appreciate what you're saying in terms of you can't, legal fees are not an option. So I'm more than happy to have a half an hour chat and just give you my views on it and whether it be worth instructing a lawyer. And we'll take it from there.
Fantastic, thank you. I thought that might be the case, so thank you. Very similar question, says Sarita.
Yep.
Very similar question, sorry. I create content, either video or photographs for brands.
Yep.
I've often given them permission to share my work on their own social media channels.
Yep.
Others have said I should be paid extra for them using my work. However, is this so? But how would you charge?
Sure. I guess it comes down to, have you decided on assigning your rights, i.e. have you been bought out, and have they bought your rights wholesale and they've become the owner and they've paid you a fee? If that has happened, then at the time you decided to sell your rights for a price, that means that they become the owner of the work and they can do what they like with it after that point. If it's a situation where you have only licensed your work to them, you would have licensed it for certain uses, and it would be for either a fee or a continual royalty. Now, there'll be a market rate in your particular profession or the industry, whether that be fashion, art, theatre, what have you, as to what your work should command and what those uses should command. And if you've been paid a one-off fee for a license and the license allows them to use that on social channels, then no, I wouldn't expect further revenue. If, on the other hand, you're charging a royalty or a share of advertising fees where they do use your work on digital channels, then you should be seeing a share of that revenue. It all depends on what your agreement is with the person who commissioned the work.
Fantastic. And the final question here then, from Lance at the moment, is what about pitch decks where you use images to describe your story idea, where the images are not used for the final project but more used as a mood board to get the client to buy into commission your work? The images you use are often borrowed.
Grey area. Practical real world answer is unlikely for anyone to ever know, see, or come after you for infringement, because you're not using that document in and of itself to sell your wares as if you were some kind of market trader. Technical legal answer is you should have the rights in everything that you use to sell yourself. But the reality is people very rarely do. Although what I would say is I would encourage the use of images that come from Creative Commons where you've got the right to use them for those purposes.
Fantastic, thank you very much. There's another question here that Martha's just said, but we will save that one to the end if that's all right. And I'll pop that on, make sure that we catch that at the end. So
of course,
questions, do add them to the chat and I will ask them in a minute.
And we'll come back. Okay. Let me just get coordinated on my second screen here. So we're going to talk a little bit about underlying rights, if I can make sure I can get rid of my chat screen and see. Okay. So, and we just touched upon this, Lance's question. You need permission to use other people's copyrighted works. And the question from the composer, who I'm so sorry, whose name I've forgotten, original idea versus pre-existing work. Just to say a little bit more about underlying rights, really good question about who owns a work where there's been more than one co-author and it goes through a period of development and adaptation and becomes a derivative work. That's true of a theatre or a film script. It's true of a musical arrangement. It's true of a fashion shoot where you've got a mood board of 100 different things that you've used for inspiration. It's really important, and it's really important that if you want to be taken seriously as a creator and you want to protect your rights, that you will treat the rights of others with the same respect. And the reality is, in the creative industries, is that the best artists steal. That's the reality, and people will do what they can get away with, and if they get caught, they'll pay settlement monies later. But on the flip side of that, the question that we had in from the lady who's in a dispute with her previous partners, her commercial partners, that's the flip side of what happens when an idea gets ripped off and you're not fairly remunerated for it. So there's a balance to be struck between sort of borrowing and, you know, outright stealing and exploiting what has been stolen and not giving due credit or remuneration to the person whose idea it originally was. So I'm going to move on now from copyright, and we're going to touch briefly on how else you can protect your intellectual property and your brand as a wider concept. And we're going to talk a little bit about trademarks and what they are and how they operate. So they are intended to protect your trading name, your brand. They are, like copyright, a monopoly right which prevents others from unfairly using or benefiting from your brand. You can register your trademark and it will go on a central register both in the UK or in any jurisdiction in which you register your mark, usually the jurisdictions in which you operate. If you are a digital company or you're someone who operates worldwide, then it's sensible to look at registering in major jurisdictions such as the UK, Europe as a central block, and the US in English-speaking territories. Some jurisdictions will offer protection for unregistered trademarks. So trademarks that you use which you haven't paid to register, but that over the course of time, consumers have come to recognise that mark as being associated with you and your services. In the EU, you can have one registration for the entire block. The community trademark cuts down on the admin and the fees. It's very advantageous. Trademarks are a shorter duration of protection than copyright, usually for only 20 years, but this can usually be extended. What's really important is that you continue to use your brand, that you use your trademark, that consumers, customers, clients associate the mark with you and your services. Otherwise, you can find yourself open to the risk that another savvy or sharp-elbowed operator will want to come along and potentially steal your mark for their own use, and they could challenge your use of the mark for lack of use or if it becomes dormant. So a little exercise, which I'm going to have to do rhetorically because I'm aware I'm speaking to the ether, but what would you say all the rights would be? And perhaps we can do an exercise where you just quickly flip them into the chat. All the intellectual property rights that you might find in the musical Harry Potter and the Cursed Child. Have a go. Give it a couple of minutes. So I'll read them out as I get them. The book is by J.K. Rowling, yeah. Music's by Imogen, yeah. Yeah, set design. Lighting design. Didn't know Neil Austin was the designer. Stage play, yeah. Costume. Magic. I love that one. The adaptation of the script, yeah. The logo, exactly. Music, story, costume, script, and name of the play, yeah. Title, yeah. The characters, yeah, that's a great one. Yeah, the production images, the stills. Translation rights, yeah. Wow, we're getting really granular here. I'll take a few more and then I'll come back. Okay, cool. So, where's my mouse gone? Flyers and program design, yeah, exactly. You've got more than me, guys. So yes, the rights in the original script from the book, the music and the lyrics, the music masters, meaning the sound recordings, orchestrations and arrangements, any video footage, rights in the direction, the choreography of the performances, the set design, costumes, lighting, and of course the trademarks, the Harry Potter trademark, which incidentally is owned by Warner Brothers Studios because they bought it from J.K. Rowling. So, how to protect your IP? And Joseph, have we got any more questions that we want to take, or can I move on?
Yes, there's a couple here that some relate to the last bit, but I
Sure.
asked about translation rights as well.
Sure.
Because it links to one of these questions. So I'll ask that one first and then do the other two. Andra says, a bit in the same area, but what about when you're translating and adapting a written piece of work, e.g. a novel from a foreign language into a play in English? How do you go around rights in this case?
You would have to contact the original author, their agent or their publisher in order to get the adaptation rights as you would any other type of adaptation. Usually the authors or the publishers will commission their own translators to produce an approved translation of a work, whether it be a book, a play, or a screenplay.
Can I add to that? How would it work if you are translating or adapting a piece that is out of copyright, so the plus 70 years after an author's death?
The author has died. If we are talking about orphan works, then you would be free to go ahead and make those adaptations.
Cool, fantastic. The next question then from Martha is, could you tell me a bit about the rights a director of a new writing has? If the playwright of a play originally directed by director A decides to take their work to a new director, does director A have any right over the script or only over the production?
The question would be whether the director would have any rights in the new work whatsoever. It really will depend on the end product that comes out of the new collaboration. So if the playwright has originally commissioned a director to direct and that relationship breaks down and a new director is found, then it really depends on whether the new director uses any of the ideas from director A or whether they do something completely different. If director B copies or uses without permission any of the ideas of director A, then director A should get some credit. And I'll give you an example which is a bit close to home. So one of my clients is Queen, and they obviously, I think it was the year before, yes, in the end of 2018, they released Bohemian Rhapsody, which was originally directed by the director whose name has just fallen out of my head, but he left the project in some kind of controversy. And Dexter Fletcher was brought in to finish off making the film. But the original director had the credit of director, and Dexter Fletcher did not take a director's credit. That's more to do with the nuance of how American union regulations dictate who should get a credit for what work and how much of the work was done by director A and director B. But it really will depend on how much the subsequent work reflects the original work and whether director B has brought something new and fresh and totally different, or whether he or she is continuing the work of director A. And in terms of rights over the script, the director won't necessarily have any rights to the script unless the director has optioned the script themselves, or bought the rights themselves, or whether the director has contributed as a co-writer to any development of that script.
Fantastic. I will warn everyone now that someone very handily from the theatre has logged into this same Zoom. So if it does cut out, I will get us back very quickly. But it's just come up to say that someone else has signed in. Gemma again from Dance Network says, in relation to earlier, a great question about music. How do we find out who owns copyright, i.e. the Japanese national anthem?
I'm gonna come on to music. Music is a big one. In terms of who owns national anthems, I've had this question come up before in this context of the English national anthem, because I had to do all the music clearances for Harry and Meghan's wedding, and it was out of copyright because it's so old. I would imagine that the Japanese national anthem is also very old, but I can't confess to be an expert on Japanese copyright law, so I can't guarantee how long it would have been protected for. But just as a general layman's guess, I would imagine it could even be out of copyright, but you would need to just check with a Japanese music lawyer or a Japanese music industry expert to make sure that you would not be breaching any other quirks of Japanese music law in order to use it. And that, I mean the composition. If you were to use a sound recording of the anthem, then you're dealing with two separate rights. And we'll come on to music rights in a little while because they're more complicated.
Fantastic. That is the last question, so I'll leave it.
Okay.
Just before we do that, let me just press sign in, just so that I can stop anything. It looks like it's all okay, as you were. Thank you.
Okay. Let me just check how we're doing for time. Oh, I'm really behind. Sorry, guys. I'll race through. So, how to protect your IP. So, just taking it back to the basics, protecting yourselves as sole traders, limited companies, partnerships. You want to register your trademarks, or if you don't register your trademark, you want to be using your trademark, you want your customers to identify that mark with you, your goods and services. You want to think about your company name. People tend to overlook this one, but you've got to search Companies House. You've got to see that there's nobody else who's operating with a name similar to yours in a similar field, because Companies House itself will reject a company name registration where it's too similar in the same industry. And your company name doesn't have to be your trading name. You can call yourselves Limited and your trading name is Mercury Theatre Colchester. But although Companies House won't let you register swear words, unfortunately. But yes, think about whether your company name and your trading name are one and the same, or whether they'll be different. Once you've decided on your company/trading name, make sure you get your domain name, make sure you get it in the jurisdiction that you need it, make sure it's not registered limited.xxx, because nobody is going to want to buy your services unless that's the kind of business you're trying to attract. Again, make sure that you get your email and social channel handles on all the digital platforms where you can advertise for free, set up your YouTube channels. If you are so modern that you are TikToking your dance moves and your choreography, then make sure that you get all your names on there. And make sure that you're using your brand, that you are creating goodwill, brand recognition from your customers, your clients, your users. How else do you protect your IP? The big one, which is why they've got a lawyer on the call rather than anybody else, which is contracts, the boring stuff. What's a contract? It's a binding agreement between two or more people. It usually involves an exchange of money or money's worth, but it doesn't have to. You can exchange for a peppercorn or a pound. In some jurisdictions, it doesn't have to be in writing or in a formal format. That includes here in England. You can have a contract verbally and you can have a contract by conduct. It doesn't have to be written down, but anybody will tell you that you absolutely should have a written contract where something of real value is passing between you and the other person. And that's the benefit. Types of contracts which might be useful to you guys. The first will be what we call an NDA, or a confidentiality agreement, non-disclosure agreements. These are typically used at the beginning of projects or to have discussions with unknown people who you'd like to discuss an idea with, but you want to make sure that they don't steal it. The real world perspective on that is that a confidentiality agreement is not necessarily going to stop somebody from stealing your idea. So let me remove that naivety that a confidentiality agreement is an ironclad insurance policy against it. What it is a deterrent. And what it is an insurance policy that you've got it in your back pocket if someone who you have spoken to and executed an NDA with goes ahead and uses an idea that you gave them during the term that the NDA covers. And so how NDAs would usually work is that they would say that the parties wish to enter discussions about a purpose, usually a project or a piece of work which is identifiable. And it can be mutual. It could be a discussion where you're both sharing ideas that you don't want the other to take, or it could be unilateral where only one of you is sharing the idea and therefore you want to protect yourself and you want to make sure that the other party doesn't go ahead and use it. And usually you'll have a definition of what confidential information means, and for you, the disclosure, you want that to be as broad as possible so that nothing you tell them or anything to do with your business, your commercial arrangements, your know-how, your financial information, your creative ideas can be used by them, and they should have restrictions on disclosing that information. Some of the reasonable reasons that they might need to disclose certain information would be if they were ordered by a court to do so or by law. Otherwise, they should not disclose your confidential information whatsoever, and there'll be a term for which they should keep stum. And you would usually look at anything between 3 and 5 years being reasonable. If anybody slaps a confidentiality agreement in front of you where the term is indefinite, either they need to be Apple, Google, or God, or you need to push back and say, I'm not going to be subjecting myself to an onerous obligation to keep this confidential for all of time, because the information might become worthless over time anyway. Moving on, and we touched upon this in terms of commissioning work and photography, grants of rights. You can grant any rights that you like, whether that be in your screenplay, in your book, in your sound recordings and your compositions, performances. If you want to sell your rights for a hefty fee, hopefully, then you're absolutely entitled to do so. And the consequence of that is that the purchaser will then be the owner, and you, in return for having sold them, will have a hefty sum in your back pocket, but you will no longer be the owner of those rights. The carve out to that is where you need the right to use or show your creation for your portfolio or for professional purposes, you should make sure that you carve out, you grant your rights to the new owner, and then they license back to you a right for you to use that creation for certain purposes. If you don't want to grant your rights, if you don't want to, like J.K. Rowling, sell everything to Warner Brothers and just license it, then you can choose to license your work for a fee. And an exclusive license is almost ownership. It's, I guess, the difference between owning a freehold property and owning a 999-year lease. What's the practical difference? But an exclusive license at least has a reversion of the rights at the term of the license end back to the original creator and owner, rather than the purchaser being the new owner. And a non-exclusive license is exactly what it says, which is you've licensed to somebody the right to use something, but you've reserved to yourself the right to license it to others, and therefore commercialize and exploit it through multiple channels. And the terms of a non-exclusive license, you have to be very careful about territory, about who gets what rights in what territory, how long they get them for, what's the terms of the non-exclusivity, are there certain things that they can and can't do. And you've got to be thinking about, because it's non-exclusive and you want to use it in multiple places, whether those multiple uses may or may not conflict, or whether they might dovetail nicely together. And then very broadly, talking about commercial agreements. So all the things outside of grants of rights and protection of rights that you might need in a creative context, and particularly within theatre. So I'm just going to move to here for 1 second. So theatre agreement, so an agreement with the theatre itself to put on your play, co-production agreements, investment agreements, who's going to pay to develop your idea, performer, actor, musician agreements, crews, suppliers, purchasing props, purchasing equipment, advertising, tickets, you name it. Let me just see if I can go back a slide. So this would be the example of an assignment wording. I'm not going to read it to you because you guys can read, and you're going to have it on the slides, and you don't need to be bored with legalese, but it just gives you an idea of what it looks like when you assign your rights in order for a fee, usually, hopefully, a lot more than £1. Okay, moving on. Other types of specialised contracts that you might need: employment contracts, crew, usually crew rather than performers, collectively negotiated agreements with trade unions if you are in a unionised part of the industry, standard form agreements, terms of business, creative agreements, and intellectual property issues, which we've already discussed. What goes into creating a new show? So I think we've discussed this when we did the exercise of what rights were contained in Harry Potter and the Cursed Child, but just for your reference, I've listed them out here. And again. So before we go on to clearances and music, and I'm aware that we're running over, have we got any more questions at this point, or shall we move on?
Yeah, just a couple. So there's a couple that have come in privately. One out of interest, with regards to things like stand-up comedy, but also can be related to sort of other work. How do you avoid people using the defence of linear thinking, like similar jokes, or is that too big a question to ask?
That's one I'm going to have to go away, find out, and come back and give you the answer, which I will do straight after this.
Marvellous, thank you very much. Another one, you were talking about granting of rights and then relicensing yourself to use it afterwards.
Yeah.
Can you grant rights and license the use of the work at the same time, or do you need to grant the rights and then claim the license back? If so, once granted, what happens if they decide not to license it back to you? Sure.
So it will be a negotiation. It'll be contemporaneous. So the legal logic flows that it's a grant and a license back, and that's the term of the commercial agreement between you and the other party, that they agree to do that. They could renege on the license once it's been granted, but what you would have is you would try to draft in provisions that would mean that they would be mandated to license it back to you for a period of time or on certain terms. And the only way in which they could get around that was if they amended the agreement with your permission. So it's about making sure that at the time you're drafting the agreement, and it would be within the same agreement, so it'd be a grant and a license back within one agreement, and you or your lawyers would make sure at the time that that is what the parties intended and wanted to happen.
Amazing. Tom Lightbody, who is a lighting designer, says,
Hey, Tom.
can you establish the right to use photographs, for example, when you are not the person contracting the photographer? I'm a lighting designer and need images to represent myself, my website, portfolio, etc. But most of these are taken by photographers under contract with the show or theatre rather than with myself.
Sure. Again, that's a grey one. So technically you need their permission, but in reality, it's showing your work and they are unlikely to have a massive problem with you doing that. What they might have a massive problem with you doing is if you were going off and licensing their photographs to Getty. So the technical answer will always be you need permission. The reality of your use is that you're using it to show your portfolio, and arguably there might even be an implied license that you can do so because the photographer hasn't kicked off. But again, the technical answer is you need permission.
Fantastic. Sarita says, how would you draw up these types of contracts if you yourself had to produce a contract?
Call a lawyer.
Good question, good answer. Ollie says, I'm a director and created an idea for a play with a writer within my company.
Yeah.
They then invited a co-writer to develop the script with them. We called it a commission from the company, although as it was all unfunded, at the point no money changed hands, etc. We got as far as a scratch version, but now we want to develop it further, but probably without further input from the co-writer. What should we be aware of going forward in terms of rights on a full-length piece?
You should have a look at the extent to which the co-writer that you're now seeking to exclude has contributed to the piece that you're creating and working on. But I think it's a question of waiting until you get to the end of your development stage and seeing whether that contribution is still even recognisable, because by the time you get to the end to a script that's ready for production or investment, it may be that that person's contribution has been whittled down so much that you may seek to give him credit and a share of revenue or royalties, or it might be that you decide that you don't want to do that and he might have to fight to be recognised. Or alternatively, you might take his idea and develop it and run with it, and it might be the main leitmotif of the work. It's hard to say. It will all depend on the finished product and how much of that person's work is still there and recognisable and in a sense detachable from everything else that gets created afterwards.
Fantastic. And the last question then, which should be a relatively prompt one, from Hannah Brailsford, who is a oral storyteller. She says, do I have any rights as an oral storyteller over my version of stories when many storytellers tell the same story? Is my version protected?
That's a really, really good question. And it's akin to a musical arrangement in many ways because it's an adaptation of a prior work. And the answer is, if it is told orally, the way that I'm speaking to you now in the air, then possibly not protected. It would be protected in a different way if it were recorded. So if you were videoed, or if there was a sound recording made of your oral performance, then that recording would be protected, but the content of the story itself may not be.
Fantastic. That's all the questions. Back over to you.
Okay, cool. Okay, so I'm aware that we're over time, so no offence if people are dropping off and want to get to their dinner, children, other halves, or what have you. I'm going to try and run through clearances and the use of music, because that can be something that often trips people up and it gets very expensive, complicated and stressful. So if you want to record, and in the context of theatre, if you want to record a theatre show, you'll need permission from the owners of the underlying rights to replicate their works, as we've discussed. So the script, the creative team, the performers. So making recordings of theatre involves a hell of a lot of rights. It could include things like logos, insignias, but there might even be rights in how a character is made up. actions, gestures, movements, choreography, they could be protected as a dramatic work, and wardrobes, props, lighting design. So if you are recording a theatre show, you've got to make sure that you've got all the rights and everything that's contained within that body of work in order to commercialise that recording. On to music. There are 3 separate copyrights, although we tend to lump 1 and 2 together and say that there are 2. There's copyright in the lyrics, there's copyright in the musical score, and there is copyright in the sound recording of the composition. So I'm going to talk about compositions and sound recordings, the composition being music and lyrics together. Who owns the original rights in any song? The composer and lyricist. So if you're talking about an Elton John song, for example, then he and Bernie Taupin write together. So Bernie tends to write the lyrics and Elton the music, or Lennon and McCartney, for example. And then the copyright in the sound recording is usually the producer of the sound recording, and that's usually the record label who pays and arranges for the sound recording to be made. Grand rights are those rights in music for music which is used in a dramatic performance. So ballets, theatre, dance. Who owns the rights in practice? So when you are looking to clear a piece of music, you will deal with at least 2 bodies and 2 sides of the music industry. If you're looking to clear an actual sound recording, a track, then you will need to speak to both the record label who owns the master rights and the music publisher who owns the composition. If you are just looking to clear the composition, say you want to clear a song for Les Mis and have it performed and you're just using the lyrics and the music, then you will only need to speak to the music publisher. You may also need to make sure that you have the right to publicly perform both the composition and the master recording. So where can you get the rights? Directly from the music publisher or the record company, from the collection societies who collect royalties on behalf of performers and composers. And it depends on the type of composition or track you require, and it depends on how you're going to use it. The most expensive type of use would be syncing a track for advertising or for film. And if you are a little student production out in Argentina and you give a big band, who I won't name, a call, sometimes they're generous and say, yes, if you're using it for your school play, we don't mind. Who owns the rights? So it's just a chart showing you how the rights flow. So on one side, you've got the composers who license their rights to a publisher who administer them for them. And then you've got the performer who performs the sound recording, which is owned by the record label, who then administers the rights in the sound recording. And then you, Mercury Theatre, licensing both sides of the one song, get to use that song in your productions. I'm going to scoot over collection societies because they're not vital to your sanity and information, but you need to know they exist, why they exist, and you need to know that sometimes it will be they who have the rights to license music rather than the publisher, usually the publisher versus the record label. You would usually need to speak to MCPS or PRS. They license music for certain purposes. So MCPS for online, the right to make copies and use online, and PRS usually administers public performance, broadcasting, and they have various schemes and tariffs. And this gets very complicated because it really depends on how you're using it and who you are. So if you're a theatre company, you'll have a PRS blanket license anyway for the public performance of music. If you are a small company who's looking to sync a track with a piece of audio-visual content, you'll need to go and get a sync license, and you could be dealing with MCPS and PRS, or you could be dealing with the publisher and the label. It all depends on what track you're trying to clear. You might also need to clear public performance with PPL, who administer the performing rights for sound recordings, or VPL, who administer the rights in music videos. And just to make you aware, as if it couldn't get complicated further, if you were to decide you wanted to use a foreign piece of music which was not in Anglo-American catalogue, then you'd have to also deal with the overseas collection societies. And whatever you do, try not to use Brazilian music, not because it's not beautiful and wonderful, but because the collection society system in Brazil is extremely corrupt, and trying to get any rights out of Brazil is impossible, very nearly. In terms of commissioning music, if you decide that you want to leave alone the quagmire that is musical clearance and commission your own music, which I advise, then you're going to need an agreement with a composer and or a lyricist to commission the piece of music, whether that be an original piece of music or an arrangement. You'll be paying them a fee for their services, and they would also expect to receive a royalty on the commercialisation and the use. And for the theatre, that might be a percentage of the box office, or it might be a fixed royalty. It would also depend on whether you went on to make a soundtrack and license that to a record label. For scores and arrangements, you will need the underlying rights permission of the original composer. Use online. So, you've cleared your music. You've found out who composed the Japanese national anthem. You've put it into your show, and then you decide you want to use it online. And this is where the real headaches begin. It's where that emoji with the exploding head comes in. You may have to deal with absolutely everyone if you want to use it online, especially on YouTube, and if you want to commercialize it. And what I would suggest is, if it's an obscure piece of music and you cannot easily find the publisher and or record label, you might want to go to the performing rights societies. They have a good idea of who the owners are, but they won't necessarily always know. And if they cannot contact the owners directly for you, they can at least give you the details to contact, and you will have to negotiate a separate use for online use, which isn't already covered by PRS or MCPS for the composition, or PPL for the sound recording. So PRS issues general blanket licenses. Advertising and background music is not covered. Certain other uses are also not covered, such as podcasting. So you really need to have a look at the PRS website to see what would be covered for your particular use and what wouldn't be. It would be a whole separate 3-day session if we went into all the different types of uses. So I'm just trying to give you a flavour of where to look, who to talk to, how complicated it is, and think about what your use is and how you might be exploiting the music. And then this is just to give you an example of the big collecting societies in the main territories that you might come across when trying to license music for your theatrical purposes or creative purposes. So a bit of a game which may or may not work on chat, but we're nearly at the end now, and it's a spot the issues. How many rights do you think you can see in the following picture, and answers in the chat? What do you think these all are? Lighting design, I like that. Do you think, is it Westminster Borough Council over Regent Street would actually pay the licence to the lighting designer? You'd hope they would, wouldn't you? Privacy rights for the balcony, love it. Absolutely. Typography, yeah. Show title, very good. Okay, so you have design rights in the sculpture of the angel. So maybe not quite the lighting design, but definitely the sculpture. You've actually got copyright in the building. So the corner of, I think that might be Hanover Place, you actually have copyright in the architectural design of that building. The trademark of the Nutcracker, the sign on the bus, the trademark of the Met Police on the side of the police car, and you might even have on the bus, you can also see the trademark of the Royal Albert Hall, and it's not very clear, but you can see circled just in the middle above the police car is the map, the local area map that directs tourists as to where to go. You would have copyright in the map as well. Well done. But virtual ching ching. Let's move on. So this next one, let's see what you can see here. Team branding, yeah. Yeah, that's correct. Copyright in the tattoos. You don't want to rip off people's tattoos, apparently. Sponsor trademarks, yeah, correct. Shoes, the design and brand, yeah, the clothing design. Brilliant. So you've got the trademark, the sponsor trademarks, you've got the trademark of the sportswear company, so the Adidas or Adidas trademark, copyright in the tattoos, the team logos, both copyright and trademark rights in the team logos, team designs, they'll have design rights in those, and not just the copyright, but also copyright in the artwork on the shoes or the sneakers there. And then just one more. So this is just an example for you of parody, which would be fair use. So a way in which copying has taken place and adaptation has taken place, but it's not an adaptation which would be classed as derogatory treatment. It would be taken as parody or pastiche. So that is just a flavour of what that might look like for you. And then just to end on some top tips to think about in your creative professions when you're looking to protect yourselves and having to minimize your use of boring lawyers, which is the expression of ideas is protected by law. So how you record the idea, how you express the idea, but the idea itself is not protected. So if you've got an idea you'd like to exploit, record it, write it down, put it in some kind of permanent form, notes on your iPhone, write it in your notebook, take a photo, and you've created a copyrighted work which is protectable. Protect your ideas by using non-disclosure or confidentiality agreements for initial discussions. Make sure that you have these properly drawn up. They don't have to be very expensive. You can find decent templates online, and make sure that you protect yourself going into discussions with new potential partners so that you can protect ideas going forward. And in terms of granting and licensing rights, be clear about what you're gaining and what you're giving up. do you want to sell ownership of your rights? Are you happy to accept a fee for a buyout? Are you negotiating with a large partner who's got much more market leverage than you? Are you negotiating with the film studios or the television channels who want to commission a podcast concept from you, or a television format, or a play that they want to publish online? And do you have any choice but to be bought out, or do you have a choice to license? Or are you in a position where you can choose who you license to? And if in doubt, seek legal advice. You'll have my contact details. I'm more than happy to have introductory quick chats on particular issues with any of you if you've got any burning issues after this session. And if you've got budget, then think about finding yourself an intellectual property lawyer who will help guide you through the peaks and the troughs of your creative lives. Any questions?
We have got a few from a bit earlier on. Tom said, do you need to use, do you need the same rights to record a rehearsal as a finished show in the context only for, in this context only for individual use and directly related to the show in question for the development of a lighting design, as an example?
Sure. That's a really great question, actually. Hi, Tom. If you don't have your rights in place by rehearsal, I'd be really goddamn worried, because it would depend on how close you were to opening night. But no, technically what I would say to you is that if you don't have rights in place to record a rehearsal and the rehearsal is recorded, technically you've committed an infringement by making the recording. However, if you don't do anything with it and it's individual use, then query whether those original rights owners will ever know that you made that recording. What I would say to you is, if you ever sought to commercialize the recording of the rehearsal without having got the rights beforehand, and you choose to use them, say you want to use them for behind the scenes footage, or content for a YouTube channel, what have you, then I would make sure that as soon as you can afterwards, negotiate to make sure that you have the rights to commercialise not only the recording of the final finished performance, but any behind the scenes rehearsal footage, outtakes, anything like that, so that the licence includes everything that you have recorded and created.
Fantastic. Another one from Sarita says, is using 15 seconds of a song or a piece of music for free a myth?
Yes.
Done. Answered. Lisa Warnock, who runs a dance company and is a choreographer, says, if you're using music in a dance performance, is the venue PRS license sufficient?
It depends if the performance is recorded or not. If the venue has a PRS license and you are doing a performance that is not recorded, yes, that should be sufficient. If the performance is recorded in some way and commercialised, then you will need a sync license, which is separate to a public performance license within the venue. The venue is licensed to perform the music publicly for itself. You're not licensed to use that music, put it together with a video of your dance performance and then commercialise it. You'd need a separate license to do that.
Amazing. Peter has a couple of questions here. So the first one is, as a theatre set designer and maker, I've always just had a flat fee for the work and then that's it. Usually for small scale touring work, should I be negotiating some kind of future work agreement to protect the use of my work in the future, or royalties from performance for future performances? And if so, what would that look like?
That's a really great question, Peter. And I must confess, I'm not actually very close to the commercial parameters of what it looks like for theatre set designers and what your commercial norms would be. I would ask around your friends and contemporaries, to the extent you're willing to discuss it, and see what other people are doing and what the market norms are. I think to some extent, I can see why there's a one-off fee for the work, because it's a piece of set design which is created and then it's there static. where you're looking at that production going off touring, especially touring within the UK, then I don't think that there's anything wrong with asking for a royalty whatsoever. I think it will be dictated by what are the commercial norms for your part of the profession, and I think you need to find out what other people are doing there to see whether there's scope for you to argue that you should be getting a royalty where people go out touring.
Fantastic. And a second question from Peter then, in one of his many hats, is I run a theatre company and produce shows for touring, etc.
Yeah.
I work closely with musicians / singer-songwriters when creating this work.
Yeah.
They always get paid to do the work, but we've never come up with a definitive way to deal with the rights of the work after.
Yeah.
Do you have any advice on this? Is it a buyout fee, so I own? And how much is this usually? Or is it a license for me to use for touring only? Or should it be registered with PRS, etc., and the musicians would get the royalties through that way? Or any or all of the above?
Sure. That's a question with many layers. So I'll try to take them each in turn. So you say they always get paid to do the work. I'll make the assumption that doing the work means musician, singer, songwriter. So they're creating the music and they're probably performing the music. So in terms of their performance, usually you would buy it out. In terms of the composition, you would want to buy it out. They might not want you to because they would want a royalty. The real answer, so you say they always get paid to do the work, but we never come up with a definitive way to deal with the rights afterwards. You've got to think about how you're using it after it's been created, where you're using it. Is it being recorded? Is it up on any of the music sites like Spotify, Apple Music, or is it something which is a work, a score which is performed when you perform your live show? And what terms have you made your agreement with your composers and your musicians? Is it over email? Is it text message? Is it phone call? Is it in a formal agreement? It may be that these issues aren't ironed out and so they're actually still open and no one has decided them. I do have some advice. I would recommend that you email me and we have a chat about it, and I can at least help you navigate through the issues so that we can get a clearer picture of where those rights sit. Is it a buyout so I own it, or is it a license to me? I think one, it's going to depend on your perspective versus their perspective. They might think one thing and you might think another, and it will depend upon the language you've used with one another and how you've agreed to commission this work as to where those rights sit and whether they are an assignment to you or just a license. And I need to see the wording in order to tell you what I think.
Amazing. Two more questions then, because I haven't seen any others come in. Lance says, and this might be a phone call or an email afterwards, do you help register patents?
Sorry.
Lance said, do you help register patents?
Yes, yeah, my firm does. I've got an intellectual property team who specialise in intellectual property enforcement and litigation. And yes, we do register patents. Patent registration takes a long time. It can take sometimes up to 7 to 10 years. It depends on the jurisdiction in which you want to register your patent. And it depends if there's anything out there on the market similar to the invention that you've come up with. And my first piece of advice for you would be, don't even think about looking for a competing invention, because the minute that you have knowledge of that competing invention, it can be really difficult to register your patent. So you want to be quite pure and protected in the bubble of your invention and not know about anything else that's going on.
Good advice. And a final question, which was related to the Spot the Issues, the first picture.
Sure.
What happens if a photographer takes a picture unknowingly of a copyrighted building or piece of architecture and uses that for financial gain or for their portfolio of work?
Sure. It's a tricky one. In this jurisdiction, I think it's permissible. In other jurisdictions, there are restrictions against it, such as in Spain. I'll need to come back to you and reacquaint myself with the parameters for commercialisation of that, because I can't remember whether that's permissible or whether you would need rights clearance, but let me come back to you on that one.
You don't need to, because that was a question that I thought up and I don't need an answer, but I was more interested, so thank you anyway.
Okay.
That is all of the questions that I can see.
Okay.
Just checking if anyone else has done any. No, they haven't.
They're probably bored of the sound of my voice now. I know that I am.
I'm not. I could sit and listen to you talking for the rest of the evening if you're free. Thank you so very much, everyone. Thanks again. This was obviously the last session of the upskilling events that we've had this week. Tomorrow afternoon we will be joining for an hour from 4 till 5. If you would like to join and just sort of say a quick hello to everyone, because we haven't had an opportunity to speak to each other this week. This session will be added to the website, and I will copy the link before I disappear, but it is on the Facebook page. Hannah has...
Can you bleep out my swearing, Joseph?
I will do my best. I will do my best. Hannah had raised a hand, but it has now disappeared. So apart from that, I will stop recording now. Have a wonderful evening, everybody, and I will hopefully see all of you tomorrow. Thank you so much.
Thank you very much, guys.
Cheers.